Hello, my name is Liz Davies. I'm a barrister at Garden Court and I specialise in housing law. I want to talk today about the role of Article 8 of the European Convention of Human Rights and how it's helped to some extent to keep people in their homes in the last 20 years since the Human Rights Act came into force. Article 8 contains the right to respect for a person's home. That right is not absolute. If it was, no one would ever lose their home. Someone can have their home taken away from them if, and only if, the eviction is in accordance with the law, necessary in a democratic society, for a legitimate aim, and is a proportionate step. In other words, Article 8 is a qualified right. Also, Article 8 is not a right to have a home. That would be beyond the scope of the European Convention, although it is in other international treaties. When the Human Rights Act came in, housing lawyers speculated on how it would help. We thought it was obvious that Article 8 would apply where, normally, a landlord would have a right to possession and to be able to evict a tenant under a court order, but without the court considering the merits of the landlord's claim. Usually where that happens is Section 21 no-fault evictions, brought by private landlords, where the landlord simply has to show compliance with notice requirements and certain other matters, but the court cannot investigate why or consider a tenant's circumstances. A possession order must be made. That's the most common example, but there are also similar mandatory grounds where the landlord is a public authority, a council or a housing association, usually where there are 8 weeks arrears or under certain types of tenancy, or where the tenancy is ended and somebody remains in occupation but has no security of tenure. Under landlord and tenant law, the court cannot consider the occupier's circumstances. We thought that it was obvious that Article 8 would allow the court to look at the whole of the case in the round, taking into account why a landlord wanted possession and what effect that would have on the tenant. So it's a bit of a lengthy saga. It all started the very first month when the Human Rights Act came into force, in a case called Sheffield City Council and Smart. Miss Smart was a non-secure tenant. Sheffield wanted possession of her property, and I was instructed to argue that Article 8 meant that the court should consider her circumstances before it made a possession order. We lost in the county court, we went to the Court of Appeal, we lost in the Court of Appeal, and there were then a whole succession of cases in the Court of Appeal and in the House of Lords, brought by various barristers and solicitors around the country on the Article 8 point. They were called Carsey and Harrow, McCann and Birmingham, Kay and Lambeth, and they all rejected the point. Some very small steps were taken. The House of Lords decided that Article 8 allowed a court to look at the council's decision-making and whether or not it had made an error of law, but the overall point that Article 8 required the whole of the tenant's circumstances to be considered was not accepted by the court. Each time we lost in what was then the House of Lords, then cases would go to the European Court of Human Rights in Strasbourg. And each time Strasbourg disagreed with the English courts and said that Article 8 did require a full appraisal of all the circumstances to be undertaken before a possession order could be made. And finally, in November 2010, the English courts agreed. It was the very first case to be considered by the Supreme Court when it was set up for place in the House of Lords, and it was called Pinnock and Manchester City Council. And the Supreme Court finally agreed that courts should consider whether it was proportionate to evict someone from their home. That was an exciting moment for me. In November 2010, I was representing some students who were occupying their college buildings in protest at the coalition government's intention to increase student fees to £9,000 a year, part of a whole wave of student protests in late 2010. The college wanted a court order so that they could remove the occupation. We put the case of Pinnock before the judge. That was rather cheeky, I have to say, because none of the occupying students who were occupying the college refectory and the hallway considered the refectory and the hallway to be their homes. They had other places to live. But the judge did at least consider Pinnock, even though she decided in the end that the university could remove student occupiers. So it was a bit of a titanic struggle. It lasted 10 years to persuade the courts that Article 8 did mean that courts could look at the whole of the circumstances. Even then, despite the titanic struggle, it has to be said that it's of somewhat limited benefit. The point that Article 8 applies can only apply in exceptional circumstances. You will ask me what is exceptional. It is obviously impossible to know if something is exceptional, but only one case in the higher court so far in the last 10 years has been held to be exceptional. And most significantly, then the courts have held that Article 8 does not apply to private tenants. And of course, that's the major problem, since most mandatory grounds for eviction are under Section 21, no-fault eviction. So Article 8, on the whole, contains a procedural right in exceptional circumstances, which is reasonably valuable, but is not the same by any means as a right to a home. A right to a home would, of course, be a great thing, but it's certainly not to be found in the European Convention of Human Rights. It's something that we'll only achieve through sustained political campaigning. In the last 10 years, in response to austerity, to the appalling housing crisis, now made worse by COVID-19, then there have been some really great housing rights campaigns emerging, such as Acorn, the London's Renters Union, and so forth. I hope that they can campaign for Parliament to legislate so that we all have a right to a home, not just a right to respect for our homes, and I wish them luck in doing so. Thank you very much.